Hi, it's attorney Jason T. Brown, head of the Whistleblower law firm Brown LLC, fielding a question that we get asked quite often, which is, can I be a whistleblower if I signed an NDA or a severance agreement? And let me tell you, it is a very, very complicated issue. The results of that inquiry will differ from person to person, to jurisdiction, from judge to judge. So nothing in this video can be relied on. It's strongly encouraged to avail yourself of a consultation with the whistleblower law firm. But let me give you a general review of what's going on. An NDA is a non-disclosure agreement. Sometimes within the confines of a company will try to have you sign certain paperwork that, number one, makes everything there confidential. Number two, in the context of confidentiality, you can't disclose it. Therefore, the NDA, non-disclosure agreement. Now, in recent times, some courts have bared hard into these NDAs and found them to be unenforceable. I wouldn't look into or rely on that too much. There's certain regulatory agencies, such as the NLRB, and FTC with other component, which I'll talk about a little bit later, that have also laid into things like non-competes and NDAs and whether or not those are enforceable. But again, those are regulatory agencies, even if they've broadcast that they should not be enforceable. Now there is a ancillary case to the Chevron deference doctrine, and with the court, if I'm using my crystal ball, I will predict that the Supreme Court will strike down Chevron deference, and a lot of these rules and laws promulgated by administrative agencies may not survive. But going back to the NDA, a company does not have the right, and this is pretty specific, to mandate that you keep quiet illegal conduct. So generally there will be whistleblower exceptions and exemptions to any NDA. Before you, though, avail yourself of it, you must speak with qualified counsel. Do not rely on this video. But for example, HIPAA, well known. HIPAA is what protects patient privacy, the disclosure of medical records. In the HIPAA code itself, there is an exemption and an exception for individuals who want to disclose normally private patient information, protected healthcare information, PHI, but they can disclose it if they're disclosing a fraud upon the government, Medicare fraud, Medicaid fraud, potentially other types of insurance fraud. So it's contemplated that inherently has certain elements of an NDA, HIPAA itself as a law. But the NDA, there's also the SEC, which, if it's a publicly regulated company, prohibits NDA language that would interfere with the ability for an individual to report misconduct to the federal authorities or to the appropriate authorities. So, ironically, an NDA that seeks to restrict the flow of information and choke out any potential cooperation with the government may in fact be an actionable cause of action under the SEC whistleblower program. I know from the past we have filed some TCRs, tips, complaints, reports, with the SEC on behalf of clients, and the SEC has taken action against companies who've embedded language in their NDA that expressly prohibits cooperation with the authorities. Sometimes they'll have more elegant type of language, which is, before you report it externally, you must discuss it internally. That's still interference. So an NDA by itself should not be, just because you sign one or believe you're bound by one, should not be anything that inhibits you from speaking to a qualified attorney about what your rights are. More complicated question, because the NDA is on the way in generally. NDA is when you're onboarding at the company and they make you sign the confidentiality. NDA is along with all the other fun type of paperwork. Sometimes they make you sign a non-compete, and I think I referenced that a little bit earlier, because this week the FTC just gave regulatory guidance after a published rule saying non-competes largely are unenforceable. And we don't know how that's going to play out. Non-compete really doesn't rear its head in whistleblowing law, but it rears its head certainly in the context of employee rights and the ability to migrate from one company to another. But the NDA on the way in, they'll remind you of it on the way out, the company certainly, but on the way out, a lot of times companies will make you sign a severance agreement or separation agreement, particularly if you want to get paid. if the company is letting an individual go. And that is a whole ball of wax, which has all sorts of dynamics. If you sign a severance agreement, whether or not you could bring certain whistleblower actions. The answer is it really, really depends. Again, don't rely on this video. But a severance agreement oftentimes will say something along the lines that you're expressly waiving all your rights under a host of statutes. And some of the statutes may specifically articulate the False Claims Act, EEOC, everything and anything under the sun, FLSA. So in that case, it's a split of authority from circuit to circuit about whether or not, at least under False Claims Act doctrine, whether or not that severance agreement is enforceable. And you, as a potential whistleblower / relator, somebody who wants to bring an action, have the right to recover. Now, going back to what I initially said, there certainly can't be language that inhibits you from participating and cooperating with the investigation. But is it enforceable when they have language that says you can participate in the investigation, but you can't recover additional funds if you get paid on the way out? It's a matter for interpretation for the courts. Some circuits will say, did the government know about the cause of action before? Did you file the whistleblower case before you signed the agreement after? That may have a profound effect on the outcome. Who you told what to and when. So you really need to get a consultation to understand what your rights, and not just your rights, but what your options are. Because the company's going to be crafty. The company's going to try to put you in a corner, particularly if it's doing misconduct that they know that you're aware of. So when you're looking at what your options are, you have some. You can get something called a straw relator. So you can maybe feed somebody else the information, if done permissibly, legally, and ethically, and have them file the complaint, because they may not be bound by the agreement that you sign, your separation or severance type of agreement. You can form a dummy corporation. This has been done in other qui tam actions where that new entity is theoretically not bound by the NDA and it stands to recover. Now, you can understand that, again, and I've said this many times, sometimes the company has sued the individuals when they believe the individual has violated the NDA, even in the context of bringing a whistleblower case, even if it was for that exclusive purpose. Now, I think the better rationale and from the courts is to dismiss that, say that interferes with public policy and interferes with the law. But I know of at least one opinion in which the judge allowed that to go past the motion to dismiss stage. So all the more reason to get legal advice you can rely on before you take a radical step in blowing the whistle without understanding what your actual rights are. When I say blowing the whistle too, you have to consider what are you trying to accomplish. When you say blowing the whistle, you may have certain rights if you fundamentally exercise in a cognizable, identifiable statute, such as the False Claims Act, such as the SEC whistleblower program, CFTC whistleblower program, IRS whistleblower program, AML whistleblower program. But if you think you're blowing the whistle to the press, well, you may have really blown your own rights as well, and you're going to be the subject of a lawsuit for disclosing information because you didn't do it the right way. So I hope I fully answered your question. I understand there's a lot of ifs, buts, and qualifications, but if number one, you signed an NDA agreement, you still have the right to counsel. You still have a Sixth Amendment constitutional right to consult with a law firm. You should consult with a whistleblower law firm to understand what your rights are. You don't have to blow the whistle, but at least an experienced firm can tell you, number one, maybe what you want to blow the whistle on is not actionable anyway. But number two, if it is actionable, what your rights are to move it forward and what your potential upside and downsides are with the NDA. Severance agreements are a lot more complicated. Again, you should probably consult with a law firm. In a lot of instances, if you're asking an attorney or a law firm to review a severance agreement at length and opine about it in writing, that's a paid service. That's different than just a free consultation. A lot of times our firm, Brown LLC, one of the country's premier whistleblower law firms, will offer you some insight as to whether we think, and it's just based upon what you told us, whether the underlying whistleblower action might be actionable.
But there's things that you don't know and I don't know that may make it not actionable at the end of the day, such as whether you're first to file the case or not. Hope we answered your question about NDAs. We threw in a question about severance agreements. If you have any other additional general questions, leave them below. Please do not leave any confidential information or case-specific information. If that's the case, give us a call at 877-561-0000. You can speak with one of our attorneys. But if you'd like us to speak about a topic, or you just want to criticize, me, our videos, our firm, leave the comment below. Love to hear criticism, positive, negative, whatever. Just hope people are listening and enjoying these videos. Thank you for the time you're spending listening to this, and I wish you the best.